Is everything under 100 meters in the Aravallis open to mining? No, that is not true. That is a myth. Now let's slow it down because there are a lot of myths floating around the Aravalli region and confusion is doing more damage than facts right now. The Supreme Court judgment opened 90% of the Aravallis for mining. No, that is not what the judgment says. The Supreme Court addressed a long-standing problem. There was no uniform legal definition of what counts as Aravalli Hills. Different states use different maps, and that confusion allowed illegal mining to flourish. The court approved a uniform scientific definition. Hills rising roughly 100 meters above the local terrain when grouped together are classified as part of the Aravalli range. Now that does not mean everything under 100 meters is cleared for mining. Elevation alone does not decide legality. All hills under 100 meters can be mined immediately. Again, false. The judgment clearly says no new mining leases can be granted until a plan for sustainable mining is prepared, and that plan must clearly mark ecologically sensitive zones, no-go zones and buffer areas, and until that plan is prepared, mining cannot legally expand. Environmental laws no longer apply to the lower Aravallis. Also false. Environmental impact assessments still apply, forest laws still apply, wildlife protection laws still apply, central and state clearances still apply. Nothing in that judgment cancels those safeguards. So where does the concern come from? And yes, there is a reason for concern. Clear definitions can strengthen protection, but they can also be misused if oversight weakens. What happens next depends on public scrutiny, enforcement, and political will. Ignore the myths, but don't stop paying attention.